Good morning. This is Linda. How are you today?
Morning, Miss Linda. I'm good. How are you?
I'm doing well. Thank you so much. Everything look okay? Sound okay?
Everything looks okay and sounds okay. Yep.
All right. Good deal. Hi, Terry. Hi, Terry. This is Linda.
Good morning, Linda. How are you?
I'm doing well. How about you?
You look good on TV.
Oh, thank you. Flattery gets you everywhere. I was going to tell Chair Hunter when he was going through the vaccines yesterday that he doesn't know that I am available. I just haven't been able to get an appointment yet. I keep trying. I'm on so many different lists. It's unbelievable. So hopefully soon.
Yeah, I get my second one next week on Wednesday.
Did you get the Pfizer or the Moderna?
Moderna. Didn't have
Well,
any issues with it.
good. Take some Tylenol with the second dose, what I understand, especially
Yeah.
with Moderna. So, well, good luck with that. At least you've gotten it. So
Yeah.
I'm looking forward to it. So, well, I'm going to I'm not sign off, but get off of here until we're ready to go. Alexandria, are we recording right now? I think we are.
No, we shouldn't be recording.
Yeah, I don't think we are. Um, you remember the second case, correct? You remember
Yes.
okay, yeah. All right.
He's a really older gentleman.
Yes. It'll probably take a while to
Yeah,
get through his
I know.
case today. Family doing okay, Terry? Everybody
Everybody's
good?
good. Yeah.
Awesome.
Hi, Mr. Hunter. We're streaming and recording.
Okay, good morning. Welcome to the Tuesday, February 16th, 2021 session of the North Carolina Property Tax Commission. Let me begin by introducing our commission members. Vice Chairman Terry Wheeler and Commissioner Bill Peasley, Commissioner June Michaud. We're missing Commissioner Alex Guest this morning. He's having problems logging in, so he will not be with us, at least for this first one. Also, we have our counsel and Secretary Steve Pelfrey and Alexandra Bendette, our host and person responsible for doing a lot of work here at our Property Tax Commission, and Linda Garrett, who's our court stenographer. Let me also begin by reading a statement that I understand we probably should read at each session, although it's printed on our agenda and all of us are aware of it. So we see it every session. In accordance with the State Government's Ethics Act, it is the duty of every commission member to avoid both conflicts of interest and appearances of conflict. Does any commission member have any known conflict of interest or appearance of conflict with respect to any matters coming before the commission today? Okay, seeing no one is indicating a conflict. If so, as I said, please identify the conflict or appearance of conflict and refrain from any undue participation in that particular matter involved. All right, we have two matters on the calendar. We did have three, and Steve, you indicated that the HMM Hospitality LLC, there's been a motion to continue that, which has been granted due to one of the attorneys being in quarantine. Steve, I assume we need to keep that file and not dispose of it because it'll be back on, I assume, before too long to keep y'all from having to redo it.
Yes, sir. That matter at this point is session. So if that
Okay.
one way or the other, just hang on to.
Okay, thank you. And then the next case, which will be the first case, is David from Davie County, Ashley Furniture Industries, Inc., 19 Property Tax Commission 0358, which is here on a motion to compel. And the Durham County case has been settled. And the Iredell County, Mr. Frank De Felici, 19 Property Tax Commission 0561 will be for hearing. Ms. Valdez appearing for Iredell County, and Mr. De Felici is appearing pro se. So we'll start with our motion to compel, and I understand we have two gentlemen well, more than two, but we've seen, I guess, all of y'all fairly frequently. I see Mr. Sands, who's representing Ashley Furniture Industries, I believe, and is that Mr. Smith, I see? And also, I think I see Janet Shires. I don't see Janet, but I see her name appearing. Ms. Shires, if you want us to see us, you need to click on your video. And Mr. Myers, I don't see you, but I see your name. If you'd like for us to see you, if you'd click on your video. Who is Mr. Myers with? Mr. Meeker, I see you, but I don't hear you. Is he with you?
I can hear you. Can you hear me?
We can now. Mm-hmm.
Okay. Well, Mr. Myers is with the Tax Administrator's Office in Davie County, so he'll be listening.
Okay.
I'll be presenting the argument on behalf of Davie County.
Okay, so he's here on behalf of Davie County. Is there anybody else that I'm not seeing on my grid? Is that everyone? All right. Mr. Sands, you filed this motion, and I believe we've been involved in this matter before on something, I believe it was similar. There's Ms. Shires. Good morning, Janet. So we'll hear from you at this time.
Okay, thank you very much, Mr. Chairman and members of the commission. This is several firsts for me today, which is appearing on a video conference without an actual in-person hearing, which is something that I never thought many years ago that I would ever wind up doing, but we're here. And it's also the first time that I can remember that in all these years I've been practicing that I have ever filed a motion to compel in a civil matter. But the situation is that we now have had to do this in order to get at the what the ultimate goal is the fair market value of the property that is subject to this appeal. And first, I'd just like to lay some of the groundwork for the general provisions governing discovery in North Carolina are contained in 26 of the North Carolina Rules of Civil Procedure. And as the chairman, as the commission knows, these rules have been adopted by the Property Tax Commission. And the general scope of discovery is set out in subparagraph B and states, scope of discovery is that the obtained discovery regarding any matter, not privileged, which is relevant to the subject matter involved in the pending action, if it were of the party seeking discovery, including the existence, description, nature, custody, condition, and location of any books, documents, electronically stored information, or other tangible things, and the identity and location of the persons having knowledge of any discoverable matters. If the information sought appears to reasonably be calculated to lead to the discovery of the scope of discovery is very broad and has been applied as such by the courts. It is also not it's also not objectionable and subject to an objection that the examining party has knowledge of this information or can obtain that information, regardless of whether they can or cannot have access to it. Discovery is broad and allows for that information. Now, the definition of what evidence is addressed in Rule 401 of the North Carolina Rules of Evidence, which states that evidence having any, that is any tendency to make the existence of any fact of consequence to the determination of the action more probable or less probable than it would be without the evidence. That is, if it is any way related whatsoever to the evidence or the matter. It's also clear that the rules of evidence require anyone giving an opinion must provide the underlying facts and data upon which that opinion is based. Now, the second part of another part of Rule 26B is that in order to claim a privilege, 26B5 requires that when a party withholds information is discoverable by claiming that the information is privileged, then the party must do two things. One, it must expressly make the claim, describe the nature of the documents, communications, or tangible things not produced or disclosed, and to do so in a manner that without revealing the information itself privileged, protected, will enable other parties to assess that claim of privilege. That means that they cannot just on their own decide that this is privileged and we don't want you to see it, so they've got to produce it in a manner where somebody can tell whether or not it really is privileged. Now, in order to see how these general principles apply to the facts in the instant case, we've got to go back a little bit to the history of where this has been over the last year or so. In 2011, the taxpayer, Ashley Furniture, bought the vacant R.J. Reynolds tobacco stemmery and storage facility in Advance in Davie County for approximately $10 million. At that time, the property was assessed at approximately $10 million. In 2017, the county revalued all the properties. It was a revalue, and they valued the property at $87 million, an increase from 10 to 87 million. The taxpayer did not appeal that year, but did appeal in the year 2018 and subsequent years. That's why we're here today. The county initially used the cost approach to value the property based upon a schedule of values that had been adopted by Davie County. Now, upon the analysis of the application of factors to the schedule of values to this facility, the facility that was located on the property, instead of an $87 $87 million valuation. The property analysis that the taxpayer did showed that the property should have been valued for less than $25 million by using the county's own schedule value and plugging in the correct factors for the valuation. For instance, there was a discrepancy on the heating and air conditioning of the facility, the slab upon which the property was built, the quality of the siding, the effective age, and so forth. Many factors that actually indicated were not correct when they plugged in numbers. Now, some of these factors changed unilaterally and inexplicably by the county from the prior valuation when RJ Reynolds owned the property, and subsequent to the taxpayer from Reynolds. Now, upon further examination of information furnished to the county by the taxpayer after the appeal, the county, based upon the recommendation of Mr. Beck, who is the property tax administrator, upon the hearing of the Davie County Board of E&R, reduced the property's valuation from $87 million to approximately $69 million, still far in excess of the market value that should have been placed upon the property with an appropriate application of the schedule of values to that facility, or by a fact appraisal showing the fair market value of the property by one of the three accepted methods of valuation. Now, the presentation by Mr. Beck to the Board of E&R contained his opinion property was worth approximately $69 million, which was adopted by the board. And interestingly enough, at the same time, Mr. Beck or the tax department had overridden, maneuvered something property tax card to indicate that some of the factors that were incorrect at the beginning had been changed on the card. And so now the card indicated the same amount roughly that his opinion was on the opinion to the board. Now, some of the values on the cards that were changed were different and included one thing that really stuck out was they added an additional 45 acres of property that the taxpayer didn't own. So there was apparently an attempt to get the tax card to match the opinion of Mr. Beck to give the Board of E&R some idea of what it was going to be. Now, Mr. Beck presented the proposed new tax card that already had these changes in it when he appeared before the Board of E&R. Now, and talking to Mr. Beck in his depositions, he advised that his opinion was based upon the value of the property using the income approach. And in support of that, Davie County said in the sworn affidavits that they use the income approach, quote, the income approach verified by sales. And so that is where we were, trying to figure out exactly how the valuation of this property was done. And over a year after the discovery had been filed and requests been made, and after depositions had been taken, the county revealed that they did not use, quote, verified sales, end quote, and in fact had no verified sales, but relied on the income approach for the valuation of the property without comparable sales information. Now, as the commission knows, there are three methods of valuation of property to get at the true market value, the fair market value of the property, which was done and abandoned on the schedule of values initially, and the comparable sales approach, which the county indicated that they did not have any comparable sales, and the income approach. And so the county abandoned all but the income approach. So that's what we're focusing on now, is the income approach. And that's why it's so important in order to obtain the information and data upon which Mr. Beck offered his opinion to the county, and the Board of ENR accepted it. In response to the taxpayer served the following interrogatory on the county. 1, how was the income approach calculated? 2, what data was utilized? And 3, how did the county determine that the income was the appropriate method? Very simple. How was the income approach calculated? What data did you use? And why did you determine that this was the appropriate method of valuation? And should have been a very simple response and a very simple answer. This is certainly relevant and within the scope of discovery. However, in response, the county refused to provide any analysis and instead referred the taxpayer to the property record cards and indicated that the documentation would be produced at a later date. It did not make a claim of privilege at that time. Describe the nature of the documents, the communications, or tangible things not produced or disclosed, nor did it do so in a manner that, without revealing information itself, privileged or protected, would enable other parties to assess the claim as required. In effect, he did not follow the rules of discovery adopted by this property tax commission. Those rules are mandatory and not optional for any party. Later, did the county present 5 pages with conclusory numbers and percentages on them, which were apparently presented to the Board of ENR. There was no underlying data documents that were used to establish the numbers. Finally, in the deposition, the following exchange took place. I asked, what documents did you use? Documents that the tax office requests for taxpayers, whether it be tenants or renters, in the revaluation process to get rent rates. Question, from Davie County. Answer, Davie County. Question, did you furnish any of these in response to the request for production of documents? Answer, I cannot by law give, because it is not public record. Income information is not public record. Now, the charts that were furnished had only conclusory information, such as rent rate, potential gross income, vacancy, collection loss, effective gross income, operating expenses, net operating income, capitalization rates, and total value. There is no indication whatsoever that we have seen, and we've gotten over 5,000 pages of documents so far, that there's indication as to how any of these items were derived, what underlying data that led the county to use these figures. We have. This is particularly true since the county admitted that it did not have any comparable sales upon which to base any of these factors. There are many facts which we're entitled to see. Even without the identification of names and social security numbers of the parties. You know, I might point out that they even objected to giving a rentals, which obviously cannot be considered income in any way whatsoever. Now, the underlying data and information which the taxpayer is entitled to receive includes many items, not just rent rates, which could not even be considered as confidential, such as 1, the number of comparables that were used to establish a rent rate. the buildings and sizes, heights of such buildings, the building locations, the building use, the rental rates.
Mr. Sands?
Yes,
Mr.
sir.
Sands?
Yes, sir.
I'm informed we need a break for about 5 minutes, so let's take a little short break and then we'll let you continue.
Thank you, sir.
As soon as we finish that. So
Thank you, sir.
we'll take a short break. Ms. Bendette, I don't know if there's any reason to shut everyone out. We'll just stay. Anybody needs to step away, they can step away.
No problem. I will just share like a PowerPoint so people know we're on break, but everybody will
Okay.
have to control their own microphone and video.
Okay, if you probably be a good idea to go ahead and mute.
Okay.
Okay, as soon as we have everybody back, we'll go ahead. We're ready to resume. I see Mr. Peasley, Ms. Show, Mr. Wheeler, Mr. Smith, Mr. Myers, Mr. Sands, Mr. Meeker, Mr. Pelfrey, Ms. Garrett. I believe we have everyone back. So, Mr. Sands, if you will unmute, show us your video, and anybody else wants to show us your video, that will be fine. We're back, ready. It's been dead, I think. Everything ready to go still.
Yes, I didn't stop the recording or anything while we were on break, so we're good.
Okay. All right.
Mr. Chairman,
Sands?
Mr. Shires and Mr. Smith had stepped out. So you wait just a second. I don't know that I really need them, but they're part of the team.
Okay.
Let me just a second. Janet, George, let's start back. It's been cold up in McDowell County.
Well, it's just been a lot of rain. We've had some cold weather, not too bad. A couple of little snows, nothing stayed around much. Okay, I think I see them
I'm ready,
coming
Mr.
in
Chairman.
then.
Yep.
All right, proceed.
Mr. Chairman, I will get back. I try not to repeat something, but anyway, I'll start. But find data and information that we're entitled to is many things other than, quote, income and rents. We're entitled to know the number of comparables that were used by the county, the building sizes and heights of the things they say were comparable, the location of the buildings, what the buildings were used for, the rental rates and how that was derived, the cap rates, how they were achieved, the occupancy rates, vacancy and collection loss percentages, the depreciation used each and every one of the comparables that they used, the terms of the leases, and other factors which the taxpayer is entitled to see in order to compare before the fair market value of the property is actually established. You know, that is part of determining what is, in fact, the fair market value of property, and that is by having the information that is used. Now, information is contained in Exhibit H motion, if anyone cares to look at it, but as you can see, there are a number of sheets, and this is all we were given, and they are basically just conclusory information. We have no idea where they got this information, the vacancy rate, what buildings are vacant, and so forth. Now, since every approved method of valuing property pursuant to the income method, county appraisal manual requires a value to be established for the subject property by using comparable sales. And the county has admitted that it has no comparable sales. That means even more imperative that the underlying data, if there is any, that was used by the county and presented to and adopted by the Board of ENR is made available to the taxpayer. Taxpayer must have the information which allows for a determination of the fair market value of the property as is how the data actually reflects the figures of comparables and the property. The taxpayer has a right to know how they arrived at the amount that they're trying to tax the taxpayer. Now, I think Mr. Beck in deposition claimed that he used the annual gross income method multiplier, but I'm not really sure about that. But the annual gross multiplier requires that the gross income multiplier, which I think he indicated was using, that since data is required to develop a gross income multiplier, care must be taken to use only qualified sales of comparable, and they have all caps, comparable property types. The key to values using gross income multiplier is the same as any other appraisal technique, good data. Time spent qualifying the sales and determining the details of a commercial transaction is time well spent. The transaction may produce not only a useful income multiplier, but also useful sales comparables and data to derive a useful capitalization rate. And this is one of the 7 methods that the county itself says you need to do in order to have a valuation based upon the income approach. And all we have, then I think he indicated essentially we couldn't do that. So I'm not sure what the county did, and we need to have the data to find out where it came up with the all of the factors that it used.
Well, let me ask you, Mr. Sands, and we've got the motions that you filed, and we've got Mr. Meeker's response. Why don't we hear, unless there's something else that you think we need to hear, why don't we hear from him as to why they're not giving you this information that you say you need? Anything
Well,
else
I
you
can't.
want?
They have claimed a privilege, and the next thing I was going to go into was the privilege, and how that doesn't apply, whichever way the chairman wants. I think it's clear now that we have established the fact that under normal circumstances, this would be information we see.
I think they're claiming it's confidential. So why don't we hear from Mr. Meeker as to why it's confidential, and if it is, and if it's relevant and everything, why isn't there some way to work this out, Mr. Meeker? You're muted, so you need to unmute.
Can you hear me now?
We can. Mm-hmm.
Okay, well, thank you, Mr. Chairman. For the record, my name is Charles Meeker with the Parker Poe Law Firm, representing Davie County in this matter. This is a motion to compel confidential income information as to rents that is barred by 2 North Carolina statutes. This is not a choice of Davie County. These are statutes that provide criminal penalties if Davie County releases this information. Just briefly by way of background, the Ashley Furniture Plant is over 3 million square feet. It is a combined manufacturing, warehouse, and distribution facility. Mr. Sands referred briefly to the assessment in 2012 being less than the assessment in 2017. He didn't mention, though, that there had been a $40 million new building expansion built in between, and also millions and millions of dollars of renovations of the buildings. In terms of getting right to the point of this motion to compel, if I could refer to the affidavit of Michael Beck, if you each could pull that out. So I'm going to refer to that briefly, and particularly to that affidavit. Do the members have that handy?
I think so.
Okay. Let me turn first then to paragraph 3 on the first page. Mr. Becker was involved in the assessment, and he refers in paragraph 3 that the Department of Revenue courses for assessment officials, and one of those courses deals with the issue of confidential information. And if I could ask you to turn to Exhibit A to Mr. Beck's affidavit, And to page 8 of that, number 8 in a circle at the bottom. So it's about 10 pages of that document. But if you could turn to that Exhibit A, page 8, at the top it says confidential listing information. And I'll take it that you have that. It says at the top, confidential listing information. The second bullet point is taxpayer income information. And the third is information provided by the taxpayer upon the assessment. The department instructs the county to be very careful with this information, confidential or income information, because it will be disclosed. And taxpayers know that, and the county officials are told that very clearly. And looking at paragraph 4 of Mr. Beckett's affidavit, you'll see that he, like other county assessors, tried to get income information when he was doing the 2017.
Mr. Chairman, I'm
Yes,
sorry to
Adrian.
interrupt. There's a lot of moving of papers in the background, and if everybody could mute if you're not talking, that would
Yeah, if
probably.
you will, I'm trying to see who's not muted besides myself and Mr. Meeker. Looks like the ones that I can see, I think, are now. So please be careful when your mic is on. Papers, it does pick them up rattling. All right, Mr. Meeker, let me ask you this. We've read the motions that was filed and the brief that was filed, and I assume there's no dispute that the county does have some information that would be relevant to the taxpayers if they were given it. Is that correct?
That is correct. It's very limited. There are only 5 data points because most of the properties in Davie County are owner occupied, not leased. The county does have very limited information that would be relevant except for these statutes. That's correct.
Well, we had this before us one other time regarding confidential information, and an agreement was worked out that I signed and each of you signed, Mr. Meeker and Mr. Sands. And I think that was regarding the Ashley Furniture's confidential information. Is that accurate?
There is a confidentiality order as to Ashley's information. This is not a policy of Davie County. These are statutes of North Carolina that Davie County is complying with, particularly since they have criminal sanctions.
Well, but there is an exception, I think, for a court-ordered where confidentiality can be, the material can be provided, and it can also remain confidential except for the parties that are authorized to use it under that confidentiality agreement. So tell me why that shouldn't be the case in this matter.
Well, you're absolutely right, Mr. Chairman. There is a provision on court orders on the public record statute. The reason we think that the commission should not do that is not so much in this case. Of course, the commission is similar to a court order, not identical, but we believe that would be a bad policy in the sense that taxpayers are already hesitant to provide income information. Again, these are third-party taxpayers. This is not Ashley Furniture's information. These are other taxpayers in Davie County. Taxpayers are already hesitant to provide that, even though they know it's going to be kept confidential. If they know it's not going to be kept confidential and it's subject to this commission making it available to third parties, it will be very difficult, if not impossible, for Davie County and other counties, because other counties do this, to obtain information from taxpayers. So I think there's real harm, not so much in this case, because
just a minute. I don't know.
Mr. Chairman, I don't think
Mr.
either one of
Sands, wait
these.
just a minute. Mr. Sands, wait just a minute. We'll let you have a chance in a minute. Mr. Meeker, why is that an issue if the information is redacted so you can't tell which individual taxpayer might have provided it?
Okay, well, I mean, I guess that could be done. The issue then is, are they going to be allowed to ask, as Mr. Sands suggested, how big the plant was, what part of the county was in, how tall the buildings are? Are they able to ask about things that will in effect identify the taxpayer? I guess that's the question. If they just got the raw data, that would be one thing. If they're allowed to then inquire and find out who the properties are, then of course that whole purpose of that is then nullified.
Well, but isn't the purpose to keep the public and other competitors from having the information for that, where you've got a court proceeding or a commission proceeding And if information is relevant, shouldn't the taxpayer have some way of being able to view that and determine how the county arrived at that? And what if they could identify the business by the dimensions? What harm would that be if they're under a confidentiality agreement not to disclose it?
Well, I think the harm would not such in this case would be just in general that taxpayers knowing information can be disclosed to other taxpayers in the county, then would be even more hesitant to provide this kind of information. It would just be a bad policy. I think General Assembly has set the policy here, both on the Public Records Act as well as the part of the Machinery Act that deals with this information that's provided that's not required for the tax abstracts. I think that policy has been set by the General Assembly, and it's one that we're not sure ought to be done. If the commission is going to go down that path, I think the commission needs to clarify so the parties know exactly what additional information can be requested besides the rent information. However, we don't think that's a good idea. We think it's a bad policy. And the real issue here, Mr. Chairman, is what is the market rate for rental of this kind of properties? And that is something you determine by looking at the market, not so much the fewer transactions that the county has. So we feel that the taxpayer is not really prejudiced here. The taxpayer can go out and say, well, we think you use the wrong rental rate, and bring in other information from the market.
Well, one statute, the first statute you're talking about is 105-296. And that talks about specific things. Is that relevant? The things that are protected there to a real property?
Yes, it is. 105-296H is not limited to business personal property. It references property there. And if one looks at the abstract language, abstract is used in regard to both real and personal property. It is not restricted just to business personal property by the language of this statute or anything else. And this information is information that the county reached out to get from taxpayers by telephone calls that is not required on the abstract. And if you look at section 105-302B, you can see that the word abstract is used in connection with real property as well as business personal property. So this information, I think, is squarely the kind that's provided here. And of course, the Public Records Act has a similar provision. This is exactly what the Department of Revenue teaches about, and this is what we think would be a bad policy.
Well, let me ask you this. Couldn't you, it talks specifically about submitting a detailed inventory, statement of assets and liabilities, or other similar information pertinent to the discovery appraisal of property. What of this information that's at issue here would be under that?
It relates to the appraisal of real property.
What about what you exclude the inventory, statement of assets and liabilities, and other similar information pertinent to that? If you exclude that, couldn't you give them the rest of it?
Well,
Be protected.
What you're asking for is the rental information, and this exclusion here makes clear that information provided that's pertinent, that's not part of the public record, is something that should be kept confidential. I think it's the purpose of that is to, if the taxpayer provides additional information beyond what's required on the abstract, then that's to be kept confidential.
All right, Mr. Any other argument, Mr. Maker? We'll hear from Mr. Sands and from the commission members.
I think that covers it. I think the chair has gotten to the heart of the matter here in that this rental information is income information. It's protected by both the statutes we've cited, and we feel that it would be a bad policy in terms of how it would affect not just Davie County, but other counties that gather this kind of information. It's already hard to get. If it starts getting disclosed to taxpayers and appeals, then it may not be possible to get it all. At least it'll be much harder. So we think this is a bad idea, as well as being, in violation of what the General Assembly has set out here.
All right, Mr. Sands.
Yes, Mr. Chairman, we think it'd be a worse idea to violate the North Carolina Constitution, which requires due process. And if people are going to take your property, you ought to know what they're doing. And let's look at 296H, which is the statute that he kept citing over and over and over again in the depositions and his written word. That's the only thing he cited. And as the chairman correctly pointed out, at the last sentence in there says, as an except as may be necessary in listing or appraising property in the performance of his official duties, being the tax assessor. That is a specific is appraising property, and that's exactly what they did, and that fits right in the teeth of that exception. And secondly, the other one they cite, 153A, which we had never heard of, and if you want to go through a long list of depositions, you can see we tried to find out exactly what their concern was. And you know, again, I sort of think that they thought the 296 was going to apply and was going to save them. I think once they finally actually read it and see how here, then they come up with something else, and that's what they did with the chapter 153. And chapter the 153, 148.1. We need to give some of it some historical context. And that certainly doesn't apply to valuation of real property. This was part of the 1993 Revenue Laws Study Commission rewrite of tax laws, with sharing of information between the counties and the state, dealing with rental sales income taxes, so the counties could in fact share that back and forth. It was originally under 105, chapter 105. That was changed only to affect the state Department of Revenue, and then this 148.1 was added as part. And Cameron may even remember that. I know you were very much involved in the Revenue Law Study Commission, as was I. But this was placed in 153A, Article 7, and I think we need to look at why it was placed there. And this was not 148.1 was not placed by the reviser of statutes. It was done by the legislature. It was in the House amendment that came back over to the Senate, which was concurred in. And 153A 146 gives, this is beginning of Article 7, gives the general powers to impose taxes to counties, and says specifically that a county may impose taxes only as specifically authorized by an act of the General Assembly. And the power to impose a tax also includes the power to provide for the administration of that tax in a manner not inconsistent with the statute authorizing the tax. This clearly requires the property tax This clearly requires property taxes to be administered under the Machinery Act, not under Chapter 153A, since the ad valorem taxes were authorized by the Machinery Act, Chapter 105-272. This Machinery Act provides for the machinery for the levy and collection of taxes by counties. Procedures are under the Machinery Act. 147 specific, 153A 147, the next statute in order, specifically provides that the county provides the county a remedy for collecting taxes, and specifically excludes other than property taxes. 153A 148 allows for the imposition of certain taxes, but specifically excludes taxes levied on properties under the Machinery Act. 148.1 following in line obviously does not affect the Machinery Act. Remember, it has to be administered under the tax in which it was administered. So this clearly does not apply to that. And again, it would be an order of court, which the commission is, and would also be subject to other laws, which would be the Machinery Act, the Rules of Civil Procedure, and the Rules of Evidence. And I remember it wasn't long ago, the commission decided it was appropriate, not appropriate, for the commission to go outside the Machinery Act itself, even staying within Chapter 105, not going all the way to Chapter 153A, to stay inside Chapter 105 to determine that we couldn't go outside the Machinery Act to look at a definition of a sales. What is a sale? So I think the policy that's predicated upon the prior rulings of the commission and standings of the commission, that if we got a Machinery Act case, we got a property tax case, we stay within 105 and in the Machinery Act. And so I think that neither one of these apply. I think obviously we're entitled to them, and the general rule is we're entitled to it, and I don't think they have proved and come anywhere close to citing the exception. We're willing to do that. The commissioner, the chairman, or anybody would say we're not trying to get this information out there, but we're certainly entitled to see if in fact they did have a sufficient number of comparable information, comparable data to make their opinion valid. And we honestly don't think it's there. We think we're entitled to see it. And sometimes the old saying, he does too much. We have really gone over this for over a year, just trying to find out the simple things. What did you use to value it? Why did you use this? And, we just like to see it. Thank you, Mr. Chairman.
Mr. Maker, in response and then questions from the commission members.
Yes, just a very brief response. Chapter 153A, 148.1 confirms the state's policy on prohibiting the disclosure of income information, such as rental information. And then secondly, on 296H, that does deal with additional information that was gotten by the county from other taxpayers on a confidential basis in connection with the appraisal of property. And that's the reason it falls squarely within 296H. Mr. Sands has criticized the county. The county is trying to comply with statutes that exist. It's not trying to hide anything. This is very little information here. It's not going to be of much import to this case. And the county is simply complying with the statutes and thinks this policy as set up by the General Assembly is a good one, and it helps it and other counties obtain this kind of information.
Okay, questions from commissioners. Mr. Wheeler.
Mr. Meeker, how would you see one being questions at the hearing of the appraiser?
Well, I think what you would do is, the assessor is the one who's done the income method. And if you look at Mr. Beck's affidavit, Exhibit B, you can see that they have the exact income method that was used by Mr. Beck and approved by the Equalization Review Board. What they're missing is the limited backup data for the rental rate. That's the second on each of these items. And they could present other information from the market saying they think those rental rates are wrong. And of course, Mr. Wheeler, I think as you and the commissioners know, these cases typically don't turn so much on the assessments. They tend to turn more on third-party independent appraisals. I know the county's getting one. I assume the taxpayer get one. That's probably what this case will turn on. The exact rental rate used by the county income method isn't likely to be a determinant factor. So what they can do is they can look at that rental rate, and if they think it's improper, they can present evidence from the market saying, well, we think your rental rates are too high or otherwise not proper.
What about Mr. Sands? I read this in the statute yesterday, talking about the exception of releasing information that necessary in the listing and appraisal of the property. Doesn't that give the appraiser the out to share that information?
I think that really relates to information from that taxpayer that's being released to a third party. I don't believe that relates to third party information from other taxpayers. I don't believe that covers releasing their information. And that's what we have here is these are other taxpayers, not party to this appeal, who provided information in 5 cases.
All right, thank you.
Other questions from commissioners? Okay, short response before we go into executive session. Mr. Sands.
I'm sorry, I didn't hear it, Mr. Chairman.
Before we go into executive session to discuss this matter, any further response?
No, No, sir. Just briefly that, we've got an opinion from the county, from the assessor. And as Mr. Wheeler points out, how are you going to cross-examine if you don't have the information? How are you going to compare if you don't have the information? He may have an appraisal, he may not. Right now, we're on the appeal from the Board of E&R.
All right,
Entitled, and we're going to have to prove that it was wrong and properly done as part of our burden of proof. And it's going to be hard to do if they keep hiding.
Mr. Meeker, anything further?
No, I think you've heard the county's position and how it's complying with the two statutes in question. I do think if the commission is thinking about allowing some of this out, that may be clear on what additional questions can be asked, how much redacting is done, and all that, so the parties will know going forward as to how sort of into the individual third-party taxpayers, how much that information can be obtained by Ashley, since that would, obviously compound any harm here. Of course, we think there should not be, we shouldn't go down that path at all.
Okay, I don't see any other questions from commissioners. So, Ms. Bendit, if you will take us into executive session, and we will discuss this matter.
Yes, sir. Not a problem. Give me just a minute or two here. All right, I think that was everybody that was included. We are back. Whenever we go back to regular session, just note that all the microphones are muted.
Okay, I think I see Mr. Sands and Mr. Smith. Don't see Ms. Shires, but her it shows that she's with us, and Mr. Meeker, there's Mr. Meeker. So I believe we have everyone. Commission has discussed this matter and decided that there has to be a balance between protecting the confidentiality of so that the county does not violate any statutes, but the taxpayer needs relevant information to be able to prepare its case, and especially since so far it's been based on the income method. We think that this information would be relevant and should be made available, and has decided that we're going to ask you all to get together and see if you can work out an order, and that I'll be available as the chairman to work with you to resolve any disputes. But we want to see the taxpayer have available information, and we want to protect what is confidential and needs protection. But we do feel that the commission has the authority to do this, and we want to protect your assessors and anybody else that might be disclosing information from being obviously prosecuted. So you two guys, Charlie, Sandy, y'all get together, see if you can come up with something that protects both sides and you feel comfortable with. And then if you don't, I'll be available to try to make a final decision. All right. Thank you. Mr. Meeker, do you want to say something, Mr. Sands?
I was just saying.
I'm hearing a big echo, I think, from Mr. Meeker. I'm not sure, but Mr. Sands, did you have?
Thank you, Mr. Chair, and everybody stay safe.
Okay. All right. Thank you. We're going to take a recess. It's 10:33. Let's start the next one at 10:45. We should give us a chance to have a little break. Thank y'all very much.
Thank you.
Thank you.
You need a short break or something. then I'll take a short break. So. the
All right,
chat
Mr.
thing is
Chairman, we are
available.
all set.
Okay. All right. Well, the second item on today's calendar is from Iredell County. It's Frank DeFelice appeal, 19 Property Tax Commission 0561. The county is represented by Ms. Linda Valdez, and Mr. DeFelice is appearing without counsel and representing himself in this matter. So I don't know if y'all were watching before, you probably saw me introduce the commission members, so I won't do that again unless somebody requests. Let me start by just suggesting what our function is here today and what the burden is on you, Mr. DeFelice, and what we operate under here at the commission, required by statute and by case law. All ad valorem tax assessments are presumed correct. In order to rebut this presumption, the taxpayer must present evidence to show that an arbitrary method of valuation was used, or that an illegal method of valuation was used, and that the assessment substantially exceeded the true value in money of the property. So that's the burden for the taxpayer, is to show that there was error committed by the county under that standard. And then if you do that, then it's the county's burden to present that their valuation is correct. So that's what we'll be operating under today. Let me ask, I saw that there is a pretrial order signed by the county. Well, let me ask Ms. Valdez, excuse me, we have a town near here, Valdez.
I understand.
Ms. Valdez, y'all signed a pretrial order. I don't believe Mr. DeFelice was part of that. Am I correct?
That's correct. I did not hear anything from Mr. DeFelice in time, but for the purposes of the hearing and knowing that one was required, I prepared it on behalf of the county so that you had the county's information.
Okay. We do have exhibits from the county, and we have exhibits from Mr. DeFelice. Are there any pending matters before we get into the opening statements from each of y'all and then into the evidence?
I don't believe so from the county's.
Okay, Mr.
Perspective.
DeFelice, anything from you, any motions or anything pending that we need to resolve?
Pending to resolve? I don't know what you mean.
Anything that has to do with this trial that we need to rule on, I need to rule on before we get into the trial that you're objecting to? Any of the county's exhibits or evidence that they've submitted?
Oh, that's a lawyer function I don't know anything about.
Okay, well, if we go along, if you have something that you want to object to, we'll do it. Otherwise, we'll consider that all the county's exhibits are admitted. And Ms. Valdez?
Mr. Chairman, I did intend to object to some of the exhibits and some of the testimony, but I had intended to do that at the time of my opening statement.
That will be fine. And then as we go along, we'll rule on any objections.
And Chair Hunter, will Mr. DeFelice be affirmed today?
Yes, and we do need to do that probably before we start. Thank you, Ms. Garrett.
Okay.
Mr. DeFelice, you'll need to be sworn or affirmed. I think she'll do affirmed. I understand you've been before the commission before, so she recognizes you and doesn't have to have you show your driver's license like most people who are going to testify. So, Ms. Garrett, are you ready to swear Mr. DeFelice? And Ms. Valdez? Ms. Valdez, do you have someone who will be testifying and we can affirm them as well? And she may need to see their driver's license.
I have Miss Elliott here. I believe she maybe was sworn in at the last hearing as well. I don't know if Miss Garrett recalls. It was either her or Miss Miller. It was Miss Elliott who was sworn in before with Mr. DeFelice's hearing.
Okay.
Okay, then, yes. If Miss Elliott and Mr. DeFelice, if you will raise your right hand, please.
Right hand.
Thank you. Do you affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Thank you.
Yes.
All right. So, Mr. DeFelice, the way we operate, you have a chance to make a brief opening statement to tell us what your contentions are about this case and how it will be presented today. And then Ms. Valdez will have a chance on behalf of the county to make an opening statement. And after that, then you will present your evidence, which will be under oath. And then when it comes her turn, the county's turn, she would have a chance to present any evidence under oath that she would present at that time. So let's get an opening statement from you as to what you contend, just a brief opening statement. We do have in your file some of your information that we had a chance to review.
Good morning, ladies and gentlemen. I am Dr. Frank P. Felice. I am not an MD. I'm a Chapel Hill PhD economist. I did a MBA simultaneously, and I am a financial economist, world class. I have publications in leading journals here and in Europe. I was a college professor for 23 years, starting at Chapel Hill in 1963. I taught at universities all around North Carolina, finance and economics, probably 50-50, professor of finance or professor of economics. I am here today together with you people to accomplish three things. One, prove that the 2019 assessment for my property at 232 Paradise Peninsula Road is arbitrary, illegal, and $400,000 too high. Two, stop the illegal treatment by Iredell County that has cost me almost $40,000 in overpaid taxes going back to 1984 and is still going on. I understand that the PTC is responsible to enforce this law. Three, to amortize the liens from the deferred taxes using the overpaid taxes and get a refund of the balance. The essence of my case is valuation methodology and criminal treatment by Iredell County assessors. As an MBA, PhD financial economist, I am accepted by the North Carolina Superior Courts as an expert in scientific valuation of the dollar value of a decedent in wrongful death cases. Scientific valuation of property is much easier. The county, by admission, does not use scientific methodology in its appraisals, right, Fran? Methodology in its appraisals. One commonality, however, in our evaluation methods is that cost equals price equals value. Since there's no price on my property, it was not in the market, we use cost to value it. The problem is that the county doesn't know the cost, but I do, because I built the building. They estimate costs by using estimated replacement costs from a book, Marshall and Swift and other questionable sources. So that's my opening statement.
Okay, Ms. Valdez, we'll hear the county's opening statement.
Yes, Mr. Chairman and Commission members, thank you. Good morning. I'll be brief. The property appeal at matter here is property located 230.
Can't see her or hear her.
Ms. Valdez, we've lost your video and your audio.
Right, I can't hear her. I see. Oh,
We see you now, so let's see if we can hear you. It's frozen, it looks like, and we do not hear you, and now we've lost the video. Ms. Valdez, we've lost your audio and video. You may want to contact Ms. Bendette, since we will not be able to.
Mr. Chairman,
Here's-
she sent me a message saying that they are going to switch computers.
Okay,
I guess they're having a technical issue, but they're going to switch computers and see if that works a little better.
okay, so we'll,
And she
Uh,
does say that they apologize for the delay.
well, that's okay, thank you. So we'll just stay right here unless it appears that it's going to be more lengthy. Ms. Bendette, if they contact you again and if the other computer doesn't work, you might suggest to them if they have an iPad or a iPhone that they shut off the Wi-Fi and try using their data. And try using the Wi-Fi at first, and if that doesn't work, their data.
Sure, I will do that.
Technical issues, huh?
Yes, we have technical issues right now. While we're waiting, in the matter that we just heard, Mr. Pelfrey suggested that we should probably put something in the record about a timeline. So, Ms. Garrett, if you'll get put in the record that the parties are given 30 days to try to reach an agreement for a proposed consent order, and if not, that they can contact me, and I, as chairman, will help them resolve the issue as we had previously discussed. Anything else, Steve, on that matter while we're waiting?
No, I don't think so. I'll send an email to Mr. and Mr. Meeker and let them know about the 30 days.
Okay, thank you. Commissioner Peasley, any other information from Alex? I assume he's not going to join us in this case either.
I have not heard anything from him.
Okay.
I know that he did not intend to appear this afternoon, and so he may have just decided that this day was not going to be possible for him.
Okay, thank you. Is he supposed to be with us tomorrow?
No, I guess there was a scheduling conflict on his part, so he did not intend to join us Monday, Wednesday, or this afternoon, but will be with us all day on Thursday.
Okay, thank you. I see Ms. Valdez's box is back up. I think a minute ago it went off, so I'm not sure if this is a new computer they're trying to come on with or not. I see 2 boxes now for Ms. Valdez.
Since they logged in with the same name on the other computer, I'm not exactly sure which one they are intending to use, but I'm assuming once they're able, they'll get their sound or video up and running, so we will know, and then I can expel the other one.
Okay. Ms. Bendette, any further information?
No, they have not sent any messages or anything. I'm talking with Steve in a separate message to see if there's a way that we could call or try to assist. I'm not sure what we can do to help, but yeah, I haven't heard anything from her yet.
Okay, so if you have a phone number, you might try to call them and see if they can get on
Sure.
with the audio if they can't get the video.
Okay, she just messaged me and said that she is setting up a microphone and should be joining us again shortly.
Okay, thanks.
It's possible that they want to do it that way because they have the two parties in the room, and I'm sure it's hard for both of them to hear when one has on the headphones and the other doesn't. So I'm not sure if that has anything to do with it, but they're working on it.
Okay, thanks.
Mr. Chairman, one of
Yes,
the commission staff just messaged me and said that Lisa, Miss Valdez, was able to get in touch with him and said that she is going to go back to her office. I guess maybe there's a better connection there. So it will be about 10 minutes. I don't know if you want to take a break while they try to get this worked out or.
yeah, let's take a break. It's 11:28, so let's go to 11:45. I'd like to get this in today, is at all possible. So we'll take a break until 11:45.
Yes, sir. I am not going to stop the live stream. And if everybody just wants to keep their microphones muted, that would be great.
All right, let's all mute. Thanks.
Great. Thank you.
And you're welcome to stop your video as well.
Can you hear
All
me?
right. I can, yes. We're still on break until 11:45, but this is a good time for us to test. I can definitely hear you, Miss Valdez. I think that was. Did you want to test your video as well?
Yes. You see
Perfect.
me?
I can see you and I can
Great.
hear you. That's awesome.
Perfect.
Is Miss Elliott going to need to be called upon or anything? Do we need to test her sound or video?
You might as well. I don't think we will, but
Okay.
then sorry. And we're in separate buildings now. So
I understand. That's totally fine. Miss Elliott, if you can hear me, if you want to test your microphone and video with us really quick before we get started again. Okay, she messaged me and said yes. Okay.
okay. So we're good? Oh,
Can you hear us?
I can. I'm assuming that's Elliott. If
That's
you
Fran.
have,
well, you're echoing.
Yes, I'm
if you
here.
have headphones or anything, usually that's a little bit better as far as the sound goes. When you have external speakers like that, every time we talk, it picks that back up, and so we can hear an echo.
Okay, can you hear me better?
Yes, that's perfect. Thank you.
Yes.
Do you want to test your video at all? I don't know if it's necessary, but you're more than welcome if you would like. If not, I'm assuming that everyone is most have probably stepped away because they decided to take a 15-minute break. So if you guys would like, you can mute your microphones and turn off your video, and we'll be back at 11:45.
Thank you.
You're welcome. Thank you. Mr. Chairman, before we get started, I do want to let you know that we were able to test with Lisa and Miss Elliott, and they are in good shape, so we'll be able to move forward.
Okay, all right, it's almost 11:45. We've got 11:44, so we'll wait a second. Hopefully we'll have everybody back on. I see our Vice Chairman and Commissioner Peasley, Commissioner Michaud, Mr. Pelfrey, Ms. Garrett. Obviously, Ms. Bendette is on, so I see Ms. Valdez. So there you are, Ms. Valdez.
Thank you so much for your patience.
Well, that's fine. And I understand we have Ms. Elliott and Mr. DeFelice, I see. So I believe we have everybody back on. It's 11:45. So I think we had finished with Mr. DeFelice's opening statement, and it was time for the county's opening statement. Ms. Valdez.
Thank you. Mr. Chairman, Commissioners, we're here again. We've been here presently before you in 2018 appeal. It was heard by you all in April 2019 on the same subject property, which is 232 Paradise Peninsula in Mooresville, North Carolina. The county appraised this piece of property in accordance with Iredell County's duly adopted schedule of values, standards, and rules, and that was for the 2019 general appraisal. So I wanted to make sure that it was clear to the commission what value, when the reappraisal was that Mr. DeFelice is appealing. Based on the sales analysis and comparable property, which you have that in your packet as an exhibit, this property has not been appraised in excess of its true value. We have reviewed and included factors of Mr. DeFelice's property, which we would consider unique, he would consider unique. It's a unique structure, home, with the materials that were used, as well as unfurnished areas. All of that has been taken into account in our analysis, or excuse me, our appraisal, as it was in prior years. The county contends that the value is $789,890. This was the January 1, 2019 value that Mr. DeFelice appealed. It's a 1.236 acre tract. Mr. DeFelice's opinion of value has changed over the course of this appeal, ranging from $530,000 approximately down to $488,000, down to $388,000. So I'm not sure what his current opinion of value is, but the county's is $789,890. Again, this was based on his appeal is based on the 2019 general reappraisal. His prior appeal was based on the 2015. But based on that year and it being the 2019, I do want to enter general objections just for the sake of not objecting throughout his testimony regarding his exhibits and the testimony as it appears from those that he intends to bring in information prior to that would not be part of the 2019 appraisal. That includes the comments or his argument about the log cabin. That log cabin has been on the property since 2014 and include in prior appraisals. It also includes, I would object to any exhibits, which I believe are number 10, 11, and 14 through 24, from those being admitted. Those are the way the number that's on the upper right-hand corner. And all of those appear to be dealing with prior tax years and prior calculations and not relevant to the 2019 appraisal and how it was done. I would also object to any argument or testimony that he provides regarding statute 105-287, which appears from his exhibits that he intends to do, in that 2019 is not a year in between the general reappraisal. 2019 was the reappraisal year, so I don't believe that 287 is applicable. Lastly, I would be remiss if I didn't object on behalf of my clients, if he would please refrain from referring to them and their employees as criminals. He has done so throughout the exhibit and did in his opening statement. If he could refrain from doing that, I would be grateful. I would move to have all of the county's exhibits entered, and those are numbered 1 through 10, that were provided both to Mr. DeFelice and to the commission.
All right, anything else?
That is all.
Okay, Mr. DeFelice, first of all, do you have any objections to any of the county's exhibits being admitted into evidence?
I don't see anything, no.
Okay, thank you. As to her point about referring to anybody at the county tax office or others as criminals, I would exclude that and ask you not to refer to any testimony in that vein. And she's objected to some of your evidence. And as we get into it, probably best, Ms. Valdez, if you'll object at the proper time, and then we can
I'll be happy to.
rule on each one. Okay, Mr. DeFelice, it's your turn now to offer your evidence as to why you think the county is arbitrarily or illegally valued your property and substantially and significantly excess of its true value.
Okay, I made corrections based on that appraisal 2019. There are 3 big errors, and I made an adjustment for the fact that they did not follow the requirements of the law that says that they have to decrease the value of the property when I do legally permitted changes that decrease the value of the property. They have to decrease their assessment. So those are 4 items. They're on page 2 in what I presented to you. The first one is what they label as BAS on the card. That is actually a 4-room apartment there, and they have that valued at $240,440. Now, I don't know how they did that. I guess what they did was they said that this is a 2,700 square foot house that would cost $94 a square foot to build. That's the only way I can make any sense out of that. Both of those figures are wrong, and it's not a house. It's just 4 rooms that were completed in a building that was completely constructed. We know the cost of that. That's all in Exhibit 3, page 6, the cost of the building. And really all we had to do was sheetrock it and paint it and hook up appliances. That does not cost anything near what they say. It cost $15,278 to finish these 4 rooms. Now, the way to value the BAS is not assume it's a house. It costs $94 a square foot to build. It's marginal cost analysis. It's just how much additional cost beyond the cost of the building did it cost to finish 4 rooms. And all it needed was sheetrock and painting and appliances hooked up. So that's $15,000 to $15,278. So that makes BAS overvalued by $225,162. All right, now the log cabin. It's on the appraisal sheet as valued at $52,110. Now, this log cabin is a little kit cabin that I bought. It was shipped in a flatbed truck from Great Falls, Montana. In 2000, I paid $18,000 for it. It was put up by my son in his spare time. He was on a salary as a caretaker on the property, and he just did it in his spare time. He put it up, and I applied depreciation. I go to the IRS depreciation booklet and get the right life and procedure. I they recommend or in this business that I'm in, you're supposed to use accelerated depreciation methods like double declining balance or sum of the digits because of the time value of money. But I just did it straight line, the old-fashioned way, 20-year life. And in 2019, the value of this building was $900. Now, they have a separate card in there, and they value it like it was a separate piece of property that could be sold. That's not true. It's a part of my house. It was added on, and it can't be sold. So if they're appraising it by what they guess them it would sell them, that's all irrelevant. The value of that log cabin 2019 is $900. So that's overvalued $51,210. Their figure minus 900. Okay, now we come to OBFX. House buildings, property on the lake is largely piers and docks. And I do have a garage that I repaired there. There was a garage, and I just rebuilt it from what it was, and it's nowhere near what they say it's worth. The details on these figures are on Exhibit 4 on page 7. The details. So the correct value of OBFX is $7,530, and card has $36,000, so they're overvalued $29,140. And if you could read the small figures down on the bottom of the card, you can see how wrong it is for them to use estimated replacement costs.
Mr. DeFelice,
Yeah.
where you're referring to a card, you need to make sure we're all with you there. If you can point us to what you're talking about.
Yeah. The card is the 2019 tax card. This right here.
Where is it in the exhibits?
Let me see.
Is it one of your exhibits or one of the counties?
Yeah, no, it's one of mine. It's the counties too. It's regular tax card. Let me see. I think I've got my stuff a little bit. Yeah. Exhibit 1. In mine, Exhibit 1, page 4. Page 4 in the booklet you've got, page 4, Exhibit 1. It's the county card for 2019. While I'm looking at this, here's another error that I think is significant that the county made. Up in the left-hand side where it says use, they arbitrarily assumed that the use was 0101. That's a private personal residence. This is a commercial operation. This is a commercial building. This is not 0101. The right use would be 1007 commercial. So I think that's significant in this whole business. Okay. So now on the OBFX, there's a good demonstration of how wrong they are in using these and applying these estimated replacement costs from a book. They said that these floating docks were much bigger than they really are. They counted the water in between as square footage when they figured the price. It's 480 square feet of water inside these boat slips. they measured the length and they measured the width going up through the middle finger. And they said, okay, this square footage times this amount per square foot, which they got out of some book. And they calculated that those floating docks cost $40,000. That's not the figure down on the current appraisal. The current card has a depreciated value, and that's what I adjusted to. I took the actual cost of those floating docks and deducted from the card value, and I did the same with the log cabin, and they are overvalued $29,140 on OBFX. The figures are in Exhibit 4 on page 7. The calculations. Okay, so you can just check those arithmetic up, and it's possible I made a arithmetical error, but that's real close. I think those figures are right. So right there is about over $300,000 in overvaluation. Doing it on a cost basis. That's the way that they did it, and that's the only way you can do it because it hasn't gone through the market. There's no market price, but the crime, the violation of law, the law that is violated repeatedly by the county against me is the failure to decrease the assessment for doing something that's legally permitted. The counselor for the county wants me to just keep it to constant present situation, not go back. But this has been going on for years. But on the case of the log cabin, on the property now, that reduced the value of the property $95,433. The cabin was legally authorized to be a part of this property. That's all in the survey of the current situation of the property. That was all done. So everybody signed off, zoning and building inspector, everybody, that I could attach that log cabin to this building, and when that was done, that reduced the value of the property $95,000 because the septic system for this building was for 4 bedrooms, and is in the defendant's argument. I don't know why, but the permit for a 4-bedroom septic system is in there, along with a drawing of the floor plan of the building, and this apartment has 3 bedrooms, and when I added the log cabin on legally, it's now 4 bedrooms, and so I cannot complete the other half of this house because the septic system will not accommodate it. So that reduces the value of this property $95,000. They failed to do what the law says. The law is in there in Exhibit 5. It's General Statute 105, Section 287, 2C, where it says the assessors are required to decrease the assessment when legally permitted change that decrease the value of the property take place. And they didn't do that. So that has to be a reduction in the taxable value of $95,000. When you add them all up, it's $400,000 overvalued for these four items right here. Okay, so now we come to page 3, which is Article 13 of the Machinery Act, Standards for Appraisal and Assessment that the county always puts in their defense. This gives them legal authority to say that the market value of property is what they guess it might be, if it was sold. Now, it is not practicable, feasible, nor even possible to value my property at market value, because market value can only be determined in the market, and my house was never in the market. To say what market value is what the assessor estimates the price of my property would change hands for is not a valid valuation method. It's just a guess. What we call in science a hypothesis. Hypotheticals have no place in scientifically sound valuations. Therefore, a hypothesis by the assessor is not competent evidence of the dollar value of my property. Furthermore, one seller and one buyer does not constitute a market. In economics, we define 10 different input and output market structures. There is no market defined as one seller and one buyer. One seller is a monopolist. Monopolists set the price. One buyer is a monopsonist. They have no say in determining price. It's just take it or leave it. The way Duke Power, a monopolist, sells the land here on Lake Norman. You don't think that Donald Trump, who is in the same business I am in, building and buying rentable property, asked the assessor, how much do you think I can sell Trump Tower for this year to determine the taxable value? He does not. His CPA tells the assessor that the taxable value is the book value, the cost less massive depreciation. Appraisal values, on the other hand, are much higher, and they're used to show lenders who provide the leverage a low LTV to get a low interest rate. He would not allow an assessor with a BA from Teachers College to tell him his taxable value, neither will I. This Machinery Act, I couldn't understand why they set this rule, this methodology that is wrong, that the market value can be determined as what somebody thinks it might sell for. I read it to try to figure that out. I didn't have to read very far when I read the purpose of the Machinery Act is to, quote, raise revenue, that is, increase taxes. Therefore, defining market value as the estimated price gives the county the opportunity to say that the market value is anything they want to say it is. And they're very bad at estimating this price that something will sell for. I've checked dozens of times the actual value that's reported in the County of Deeds office for real estate transactions and compared it with the card value they have down in it, and they're miles off all the time. The worst case that I saw was the golf course on Lake Norman that was bought by Donald Trump, and he paid $3 million for it. They said that the market value was in the following this procedure, Article 13, was $27 million. They were $24 million wrong, and so there's plenty of evidence to prove that this methodology that's in that Article 13 is wrong. There's not an economist anywhere in the world that would agree that what they say is the market value can be determined by them guessing how much it could be sold for. So That's my my argument on those lines. I mean, it's just ridiculous. That law is wrong. It's got to be repealed, changed, called null and void, or something. It's no good. It's no good that when after Mr. Trump spent about $10-12 million fixing up that golf course, the county then said, well, it must be worth about 15 million now. And they said, no, it's not worth 15 million now. They just, I guess, just added the money he spent to the price he paid and said that must be what, well, that's not the way it's done in this business that we're in. Those expenditures could be expensed. Then they would expense as many as IRS would allow. You have to just go by the IRS rules, which Mr. Trump and I both agree are not fair. You can do stuff with commercial property that you can't do with regular residential property, and this is commercial property, so I follow those procedures. And now Trump said no, it's not worth $14 million. He says it's about five million, a little more than $5 million, and the county wouldn't agree. So he sent his tax lawyers down here and told these people what the correct market value was for his property, and that's what it's on the card today currently for. It's $5,366,660, which is a long way from 27 million.
Mr. Chairman, I would just like to enter an objection for the record. I don't know the relevance of Mr. Trump's tax appeal, tax card, and how that plays into this matter. So just for the purposes of the record, I'd like to object.
I just want to have in the record evidence of how wrong their methodology for setting value is. That's an example. I can pull up dozens of cases where it's off a lot.
Mr.
Chairman, we can't hear you. Sorry, Mr. Beasley.
Mr. Chairman, we still can't hear you.
How about now? Can you hear me? Okay, I don't know what happened to my headset. It was working, and then all of a sudden, apparently it's not. Okay, Mr. DeFelice, that's not admissible. I've ruled it's not relevant to your appeal, but we've got it in the record to preserve your argument on that.
Thank you.
Anything else?
Let's go through, look at these exhibits. I referred to them and we didn't look at them at that time. Let's go to Exhibit 2, page 5. This is the 2019 card for log cabin accessory building attached to the building at 232 Peninsula Road. It's a legally permitted change in use of the property, and they have the taxable value of $52,110 on this separate card. Then Exhibit 3 on page 6 is the building cost calculations. That's the value. The cost is the value. We don't have a price, so that's how the building is valued, by cost. There are the costs. The shell of the building cost $127,000. Here's all the detail, the individual items, materials, labor costs. The way to value the 4 finished rooms, the apartment, is on a marginal cost basis. How much additional did it cost to sheetrock and paint these 4 rooms and put in the fixtures and the labor and so on? It's a total of $15,278. So the grand total building value is $142,000 to 278. The BAS was overvalued 225, so the building is overvalued 225. Page 7, Exhibit 4. Here's the details on the OBFX items. The garage, which they said cost $18,300, actually cost $4,030. It was a rebuilding of a garage that existed there. I bought $600 worth of cement blocks and $600 worth of trusses and roof material, doors, labor. It's $4,000. The cost, therefore the value, is $4,000, not $18,000. The boat slips, the lumber, flotation, hardware, labor, $600. 2 men, 3 days, $100 a day, $3,300 to build them. Their depreciated value is $16,320. But if you follow the calculations in the small print down at the bottom, the square footage included $25,200 for water. So their 40,000 figure was flat out wrong. Then they got the pier down as worth $1,440. Its value is 0. It's 50 years old. It's worthless. Then they have a walkway down for $610, only costs a couple $100. So they're off on the OBFX by $29,140. There's the log cabin, purchased as a kit in 1997 when I was on my way to Alaska. Bought it in 2000, had it shipped here on a flatbed truck. They got it down for $52,000. The value in 2019 is $900. Okay, Exhibit 5. This is the physical survey of both lots. And it shows.
Mr. Chairman, I object to this exhibit. It's not a current representation of the lot as it existed in 2019.
What didn't exist?
All right, let me inquire. Okay, on your objection, your objection is that it's not the way it existed in 2019?
It's not, yes, it's relevant. It's not relevant that's not how the lot is currently configured as of January 1, 2019.
But what's different about a survey?
He changed the property line between lots 200 and 199 in 2014 to give the lot 200 road frontage. So the current lot size is 1.236 acres.
Well, let's admit it for whatever it shows. We can talk about it. You can discredit it during your cross-examination.
I don't understand. What's the objection?
I've said it's relevant for the purpose at this time. She can cross-examine you about anything that's different. Go ahead.
Okay. This shows the legally permitted change, which was adding the log cabin to lot 199. It was added simply by changing the lot line between the two lots. It was attached to the house on lot 200. And then when we changed the lot line, it was added on onto this property, and that was a legally permitted change. And it shows on this survey all the legal requirements. Everybody's signing off, the county officials and the surveyor and so on. So, it shows that this lot, that cabin, is a part of this property at 232. Now, there's 3 sheets for Exhibit 5. I counted each folded sheet of the survey as a separate sheet. So if we go into Exhibit 5A, that shows the original configuration of the 2 lots there. So you compare that with the current setup, if you want, if you need to do that for some reason. Exhibit 5B is the law, the GS 105-287 2C. Down 2C, it says that the assessors have to recognize an increase or decrease. They use it to justify increasing the value of your property in between revaluation years, but they are supposed to also decrease the assessment if there's a decrease in the value of the property resulting from a change in a legally permitted use of the property. It was a legally permitted use of the property that I have the log cabin there, and that reduced the value of the property $95,000 because I could not legally complete the other half of the house because the septic system only was set up for 4 bedrooms, and that putting that on is the 4th bedroom, so that decreased the value by $95,000. They did not make the account in their so.
Mr. Chairman, if I may interrupt for a minute, I did not receive Exhibit 5, so I thought that he was referring to 5A. I received 5A and 5B, so I would draw my objection. I did not realize that he included the 2014 survey. I had this exhibit.
Okay.
I do
That's
object as to 287 because that's not relevant with the 2019 appraisal.
All right. Well, for the purpose of what it shows, that one is admitted and you withdrew your objection as to the other one. As to the statute, the commission takes notice that particular statute is not applicable to this case, since that applies in years when there's not a revaluation made. But we recognize your argument about the particular use as it applies to the property.
That wasn't the only year that this was done. It was done every year from 2014 forward, 2014, 15, 16, 17, 18, 19, 20, 21. Every year that's been violated. It wasn't just that one year.
Well, Mr. DeFelice, the only appeal that we have before us and that we can consider is 2019 and its impact going forward. So we can't get into the prior years.
All right, but yeah. So what? It's violating the law has gone on for many years, and I'm asking you, would you please stop that? I understand that it's your authority to enforce this law. Would you please do that? That's what I'm asking. If you will enforce this law.
You'll have a chance to ask them questions later, Mr. DeFelice.
Oh. And Exhibit 6, which is something that she doesn't want to go in, and I guess you say, well, this is not relevant to 2019 is the overpaid taxes from all sources. You don't care about that, or it's not admissible evidence or whatever, but I just, and it's all based on county records. I'm not making any, I got all the county records right there. Calculations.
I understand, Mr. DeFelice, but that's not something that we're permitted to rule on. So that's not relevant in this case. We have no jurisdiction on that.
I don't want to rule on it. I just want to submit it as evidence of the criminal treatment I've been undergoing for years.
Well, and I've excluded references to criminal treatment, so please refrain from that. I've ruled that you're not allowed to argue that's criminal treatment. So please refrain from that. There's nothing that would rise to that level in what we're dealing with.
I'm not arguing criminal treatment. I'm just stating facts that are evidence. That's all. I'm not arguing. Well,
okay, we'll move on to what is relevant.
I'm arguing criminal treatment for, you said it's only acceptable for 2019. So I'm arguing criminal treatment for 2019.
Well, you can argue it's unfair, but it's not criminal.
It's not criminal?
No, sir. You can argue it's unfair, but it's not criminal.
If they violate that law, if they did not decrease the assessment for legally permitted change, that's not a violation of the law?
It's not criminal, Mr. DeFelice. So move on. You can argue it's not fair and it's not the proper method of doing it, but it's not criminal.
It's not a crime to violate that law. See, that's why I need an attorney here, but I can't afford one. That's the essence of my case. You don't want to allow me to get into anything except dealing with 2019. So I just submitted that for documentation of factual history.
Okay, well, it's you submitted it. It's just not admissible, so it's available for any further purpose if needed. Okay, if you're through, then Ms. Valdez, would you like to cross-examine Mr. DeFelice?
If I may just ask a couple of questions.
Let me say this, we'll go ahead and admit his other exhibits that haven't been excluded.
So the remainder of them?
Whichever have not been excluded. Is there any more you object to?
Just the ones I objected to initially.
And I think I ruled on all those, didn't I?
I thought you said to deal with them as he introduced them.
Okay, which ones have we not dealt with then?
It's the ones that are numbered, at least in my copy, the page numbers 15 through 24.
Those deal with prior years, and so I think
Yes,
if all of them do, then I rule those inadmissible.
She is referring to my appeal 2 years ago. I don't have 24 exhibits. I only have 6 this time.
We're talking about page numbers, Mr. DeFelice. They're numbered in here.
Page numbers you're calling out?
That's what she's referring to. Number 21 is the property tax card. 22 is it's a letter from Iredell County. 20. So we'll admit 21 and 22, and then the others 24, 23, and the others I referenced are.
Mr. Chairman, I'm sorry, but
15.
I'm sorry, Mr. Chairman, but the tax card that's on page 21 is from 2011. It's not the current year. The current year tax card.
I understand it, but we can admit it for whatever it shows. It's a record of the county.
Okay.
And the letter, we understand it's not involving this year, but
Thank
You
you.
could probably argue something that was on it in 2011. It's
I
for
understand.
our purposes, I think it's okay. All right,
May I?
Ms. Valdez, yes, ma'am. You want to cross-examine? Do we take care of all your objections?
Yes, sir.
Okay.
Mr. DeFelice, I just have a couple of questions for you. You are not a certified appraiser, is that correct?
No, I'm a PhD financial economist, which is a much higher certification than to be a licensed appraiser.
The building that you're referring to, that's at 232, I think you referred to it as a 4-apartment building.
No.
But you said it was commercial and not a
No, it's
home?
not a 4-apartment building, no. I have a 4-room apartment in this big building.
But you reside in that building, correct?
Only
That's your
because I can't legally complete it. It's a commercial operation.
It's not a residential use.
What?
It's a residential use, isn't it?
I'm just using it temporarily because I can't complete the building. It's not a resident. It wasn't built to be a private residence.
And in your current apartment, you have 3 finished bedrooms?
Yes.
That's all I have, Mr. Chairman.
Okay. Let's see, Mr. DeFelice, do you, she's finished with her cross-examining of you. Do you have further evidence or that you'd like for us to consider before we have questions from commissioners, if they have any?
No, I don't.
Okay. Questions from commissioners? I don't think I see any. So Mr. DeFelice is finished with his presentation of his evidence, and we have the exhibits that have been admitted other than those that we excluded, dealing with the prior year taxes. We're only dealing with the year of 2019, which was a revaluation in this matter. So Ms. Valdez, we'll hear from you.
At this time, Mr. Chairman, I'd like to move to dismiss the appeal. Mr. DeFelice has not provided any substantial or competent evidence as to the appraisal being done arbitrarily or capricious, that it was done erroneously or illegally, that his value is in excess of the true value. He has recited that the law is wrong, but if the law is wrong, that doesn't mean that the county has enforced it incorrectly or applied it incorrectly. Just because he's not an expert or a certified appraiser, he has not provided an appraisal to the county or to the commission. And respectfully, just because him saying that the value is wrong doesn't make the value wrong. And not having met his burden of proof, I would move to dismiss his appeal.
Wait a minute, that's not right.
Well, we're going to give you a chance. We're going to give you a chance, Mr. DeFelice. She's made a motion to dismiss that you failed to meet your burden, as I presented it earlier, that we have to operate under. So you have a chance now to tell us why you think you have met that burden, and it shouldn't be dismissed.
Well, I did provide evidence and proof that it was arbitrarily and illegally appraised, valued. I proved that it was arbitrary. The value of a 4-bedroom apartment was arbitrarily assessed like it was a 2,700 square foot house that cost $94 a square foot to build. They said it was $240,000 is the value of this 4-room apartment. That's an arbitrary way and illegal to appraise of completing 4 rooms in a building that was already built. I showed the correct way to do that is on a marginal cost basis, and I showed the actual costs in detail that this apartment cost was $15,278. You have all the figures there in Exhibit 3, page 6. That's proving that they arbitrarily, illegally valued this 4 rooms in this building. Okay. Now on the log cabin, it's wrong, illegal, arbitrary to say that it's worth $52,000 when I only paid $18,000 for it. They can only say $52,000 if it was a building on a separate lot that could be sold. They can't apply the lousy Article 13 methodology there, because that says we estimate that this building, this property could be sold for 52. It can't be sold. It can't be sold. So the only way to cost that is to go back what the actual cost was and reduce it for depreciation between the purchase date and 2019. So the value of it is $900, not $52,110. There's the evidence. There's the proof that they arbitrarily, illegally valued the property. $225 on the 4-room apartment, $51,220 on the log cabin. The cost of the pier and docks is documented there, exactly what it costs. Their figures come from estimated replacement costs out of a book. That's not right. That's not the right figures. I know the right figures. I built it. I know everything costs, and it's written down there. And there's no question that they have violated, if you don't want to call it a crime, all right, that they have violated General Statute 105, Section 287 2C, because they failed to decrease the assessment for adding the log cabin, which is a legally permitted change that decreased the value of the property $95,000. There's no question that they did not do that we're required to do by this law. So I have proved my case that they have arbitrarily, illegally valued this property, and so therefore my taxes should be reduced by this total amount. The valuation that they have for should be reduced $400,000.
And what was the final valuation of your property? You said should be valued at, I think we heard different amounts.
On the cover of the material that I provided to you, they say that the value is $789,890. When you make these 3 adjustments, corrections of their errors, they total $400,000. Then the correct valuation of this property as of that date would be $388,945. That's bringing everything up to date.
Okay. Anything else?
No, sir.
Hearing not. So at this time, any commissioners have any questions? Seeing none, then we will go into executive session to deliberate on this matter. And when we've reached a decision, we will be back, and you will be back into this virtual meeting. So Ms. Bendette, if you will put us into our executive session, please, ma'am.
Yes, sir. Give me just 1 minute. For some reason, is Fran Elliott still with us? It will not allow me to change her status to an attendee.
Can you hear me?
I can now,
Now you
yes.
can?
Yes. Fran Elliott, are you still in this hearing?
I've just asked her to leave if she is. Let's see.
It won't let me change her status to an attendee, so it's making me think that they've logged off. Okay, there we go. Thank you.
What we're doing is, y'all can hear me now, I assume, right?
Yes,
Okay.
I'm showing that we're still live.
That's fine. I'm just going to try to see if I can get my headset to working.
All right, we are all set. Everybody should be back in.
Okay, let's see. I see we've got all our commission members, Ms. Garrett and Mr. Pelfrey. There's Mr. De Felice, and there's Mrs. Valdez. All right, the commission has deliberated on the county's motion to dismiss the failure to meet the burden that we talked about earlier, Mr. De Felice, and the commission has voted unanimously to grant their motion. You did present a lot of evidence, but your evidence does not comport with the Machinery Act that we have to deal with. And so you may not agree with that, but that's the law that we have to follow. And so our reason was that your evidence did not show that the county's method was arbitrary or illegal. And so we have granted their motion. You will get a written order probably in 30 to 90 days and a letter, and it sets out our ruling and your rights under the statute. So we appreciate your presentation, and Mr. De Felice and Ms. Valdez, thank y'all very much. And unless there's further matters before the commission, and I don't see a member that is bringing up anything, we will stand adjourned until tomorrow morning at 9 o'clock.
Well,
Thank you.
we had a dismissal last week. Should we go